Welcome back to Good Law, Bad Law. Did you know that there is one industry in our country that enjoys almost complete immunity from any kind of civil lawsuit for injuries that are caused by their activities, thanks to a law that was passed by Congress in 2005? And that industry is the gun manufacturing industry. It's really quite remarkable that we continue to have a very robust debate about guns in this country, but no focus has been given to the fact that gun makers enjoy an almost complete free, get out of jail, total immunity, can't sue them for anything thanks to this law. And my guest, Dan Feldman, who is a professor of law at the City University of New York, the John Jay College of Criminal Justice, has an absolutely fascinating background as a state legislature in New York and as a prosecutor in the New York Attorney General's office, and was very actively involved in the issue of gun maker liability. Tells us the story of how it came to be that this law was passed and what the implications are for those who are victim to gun violence in this country. In 2017, the most violent and deadly year in terms of gun violence that we've had in this country as long as we've been tracking this information. So it's an extremely important, relevant, and informative conversation we have with Professor Dan Feldman. I hope you enjoy, and I hope you'll share the word and share this episode with everyone you know. It's a very important conversation. Stay tuned. Welcome back to Good Law, Bad Law. On today's episode, we're going to be talking about guns, but in a way that probably most people aren't familiar with. We've had a lot of conversation and debate this year with mass shootings in the Pittsburgh synagogue and at the newspaper in Annapolis, and of course at the Parkland High School. And so a lot of focus on things like background checks and mental health checks. But one issue that is really important to the debate and doesn't get a lot of attention, and I think it should, is an issue that my guest has a lot of experience with and a fascinating background. So I want to first of all welcome Dan Feldman to the program. Dan, thanks so much for being on Good Law, Bad Law.
Thank you for having me.
The issue, Dan, we're going to be talking about is the immunity, the near complete immunity that the gun makers in this country enjoy as a result of a law passed in Congress years ago during the George Bush presidency, George Bush II, called the Protection of Lawful Commerce in Arms Act, which is really an immunity protection for the gun makers. And you have a fascinating and unique perspective on that from your own background that makes you the perfect expert on this issue. And so I really appreciate your being on the program to talk about it. Let's start by going through some of your background. I know you went to Columbia College, my alma mater, for your undergraduate study, and then to Harvard Law School. But pick up your own personal story there, would you, and walk us through what your own background was that led you to the issue of immunity for gun makers.
Well, actually, when I was still in my third year at law school at Harvard, I unsuccessfully ran for New York City Council in Queens, which prompted the dean at the end of it, shortly before graduation, to say, "Mr. Feldman, are you aware that we have a residence requirement?" I always thought that the fact that I was able to persuade him to allow me to graduate demonstrated that I had in fact learned enough to graduate. But anyway, having lost the race, I was forced to practice law for a year.
Right.
And I got a job at one of these fancy law firms. And it was actually pretty much more interesting than I thought it would be. But I was basically helping one set of rich people fight another set of rich people. So it was hard to muster much enthusiasm. And so when I got an offer from a friend of mine, a member of Congress, to run her neighborhood office at a substantial cut in pay, I, of course, immediately accepted.
Right.
And sort of by accident, I ended up doing a major investigation for her, which was later well, became known as the Summer Food Program scandal of 1976. I guess too distant a memory for anyone who was alive at the time, and most of our listeners probably weren't. So.
And that was Liz Holtzman, right?
Yes, that's right.
And I think a lot of people probably don't remember this either, but I've always been fascinated with Watergate. But when she was elected, she was one of the youngest members of Congress.
She was the youngest woman ever elected to Congress.
The youngest woman, right. And I think she was had to have been the youngest member of what became the Select Committee on Watergate that investigated and ultimately came close to impeaching Richard Nixon. So she was something. She was a mover.
She's not only the youngest, but also in many ways, I think, the most incisive and aggressive really member. So she did a superb job. But in any case, having done that investigation, a young member of the legislature astutely figured out that I really like doing investigations more than running an office. And so he said, how would you like a hunting license to go after waste, mismanagement, and corruption in New York City government as counsel to his legislative subcommittee in the assembly? And he coupled it with another pay cut, so naturally.
How could you refuse?
How could I refuse?
Right.
And we proceeded to do some very interesting investigations. It's a whole other story, death threats, the mafia, and all kinds of stuff. But anyway, I had assumed that we would, rattle the cage, make a lot of trouble, make enemies, and I'd be looking for another job soon. But as with other people, I underestimated the fellow's political abilities. His name was Charles Schumer, and of course he's now the minority leader of the U.S. Senate. But when Chuck ran for Congress for the seat that Holtzman vacated when she ran for the U.S. Senate against Al D'Amato and tragically lost by less than a percentage point, I succeeded Schumer in the legislature.
And this is the New York State. This is the New York State
New York
Legislature.
State Legislature.
Yeah.
Yes. Some years later, I was in touch with Holtzman and with her staff, and was a member of her staff told me some work they had done on the legislative end, in which they made the following argument. When you have a victim of gun violence, whether it's an injured person or a survivor of someone who's been killed, there are often economic damages. In fact, there are almost always economic damages. And as between the gun manufacturer, for whom the sale of guns is a profit center, and the victim, who is random and innocent, entirely innocent, what is the more practical and appropriate place for the economic burden to fall? Their argument, which I agreed with, was that the manufacturer should really is a more appropriate locus of that economic burden, because, in a sense, the injuries, the economic burden, is an economic externality of that business. So I don't know if we.
Yeah, I mean, because, and this is going to be great because this really gets at the root, I think, of an important aspect of our entire civil litigation system, our tort system in this country. But yeah, explain what you mean by an externality in this case.
All right. I think the clearest illustration is in the environmental area. That is, if you have a factory that's spewing pollutants into the air, what that company is doing is imposing economic costs on the public at large. That is, well, your dry cleaning bill is worse because of the particulate pollution in the air. You may suffer emphysema or other diseases. All these burdens are really the cost of that business. And so what we've done to some extent in this country, not entirely and far from entirely, but to some extent, we've enacted legislation reimposing or re-internalizing those external costs, so that now the manufacturer either has to spend the money to install machinery that will reduce the particulate pollution, or will face heavy fines. So that way we've recaptured, we've put what the manufacturer had been imposing on the public as part of the cost of doing business, returned that cost to the manufacturer. we call that an economic externality.
Well, and there's a lot of examples of that too, where particularly with products that are deemed in the law to be dangerous products. There are companies that make explosives. There are companies that make different drugs that could be dangerous. There's all kinds of examples of that.
That's right. For some of those examples, we refer to that as absolute liability, so that if you are the manufacturer of a very dangerous product, like an explosive, the burden is on you. No one has to prove that you have been negligent in order to recover if there is a disaster as a result of the use of your product. So that's absolute liability. It's not common, but we do impose it here and there in the law for particularly dangerous products. There's some more logic to that, but I'll be getting ahead of myself when I explain it.
But just to finish the point you were making about an externality, which is a way in which your business activity may affect others in the community, whether an individual or an entire community. One of the ways that our system of law contemplates that problem gets dealt with, as you said, is that company can buy insurance, for example,
right.
and they can build into their cost of product and their cost of business a way of taking into consideration that their business activity is going to cause some harm. And rather than just saying, hey, you consumer, or maybe even you innocent bystander, you bear the cost of that. A woman who loses her husband, or a husband who loses his wife or a child, is going to suffer an economic loss, rather than that person in their society bearing that cost. We say, hey, business, you can insure that loss.
That's exactly right. But apparently the gun manufacturers were, well, it's clear to me that they didn't want to incur any additional costs, such as the cost of insurance. They claimed that this would bankrupt them, that the insurance costs would be too high. If that were true, that would suggest that the amount of economic damage that their industry imposes in the country is so enormous that the insurance premiums themselves would have to be enormous. I do not think I think they were exaggerating because they didn't want to pay anything, in fact. But if their argument had been correct, in a sense, it would argue that that's an industry that should not exist. But leaving that aside, the legislation did not get through the legislature. The New York State Senate at the time, Republican dominated, wouldn't come close to even considering it. It got through a couple of committees of the Assembly, but for complicated political reasons, the Speaker did not want to bring it to the floor, even of the Assembly. And
what again was the legislation that you were trying to get passed at that time?
That legislation would have imposed absolute liability on the manufacturers of semi-automatics and so forth, and of certain particularly dangerous weapons. Schumer, to whom the National Rifle Association had given an F because of his support of the Brady bill, he earned an F. I was honored to be awarded an F- for that piece of legislation because I would have hit them really where they lived, in the pocketbook. So that was far more effective. In any case, the legislation went nowhere. But a few years later, when I lost the congressional primary, at that time in New York, you'd have to give up your state legislative seat to run for Congress. So I ran for Congress and lost the congressional Democratic primary to another name that people may have heard, Anthony Weiner.
Oh my goodness.
Which therefore, by the way, makes me responsible for the current state of the nation, because had Weiner not been elected to Congress, no Comey letter, Hillary would have won, and so on and so forth. So it's my fault, in fact. But in any case, that's not relevant to our main story. At that point, I was appointed as the Assistant Deputy Attorney General by the then new Attorney General in New York, Elliot Spitzer.
Another infamous name.
Another well-known name.
Right. Oh my goodness.
But and that the whole Wiener Spitzer thing is another conversation entirely. But in any case, Elliot said, "I know you're interested in the gun issue. Would you like to work on potential litigation against the gun manufacturers?" And I said, "Absolutely." And so we began preparing to do that. That was 1999, and that work began in really a unique period in knowledge about the gun industry. That is, until that time, it had been generally assumed, and it probably still is by people who don't know the data, but it was generally assumed that crime guns were mostly stolen or burglarized from their legitimate owners. And that was the conventional wisdom. Now, there was a way to determine where crime guns really do come from. And for that, I have to go into a little technical detail. That is, when the police recover a crime gun, they are required to report that discovery to what was then called alcohol, tobacco, and firearms. It now has more things in it, explosives and some other things. Anyway, I'll call it ATF.
Right.
How I know the ATF.
Yeah, I think people will know the name ATF. Yes.
Right. And so, with very rare exceptions, very rare, every gun has a serial number on it. The exceptions, once in a very long while, the criminal has taken the trouble to file off the serial number, but that is extraordinarily unusual. So, overwhelmingly, it has a serial number, and of course, they can tell from the gun who the manufacturer is. So the police call ATF and tell them, well, this is, let's say, a Sturm Ruger gun or a Colt 40, Colt gun, serial number so and so. The ATF then calls the manufacturer and says, to whom did you sell this gun? The manufacturer tells them which distributor it was sold to. The ATF calls the distributor, to which retailer did you sell this gun? They then call the retailer, to whom did you sell this gun? And that information was not computerized or collected in a form that could be used for many years, despite efforts by the Carter administration and others to get ATF to do this, because Congress, at the behest of the National Rifle Association, regularly X'd out the funding to do that, and in fact, on at least one or two occasions, cut ATF's budget even further to make sure they couldn't shift funds from anything else to do that, in order to do that. However, after the Columbine shooting, there was enough public pressure so that finally Congress permitted the collection, the caution and assessment, the assessment really of this information in 1998. Between 1998, I think it was 98, 99, or 97, 98, I don't remember. But in any case, by the end of 99, that information had been analyzed. And what it showed was that the large majority of crime guns were not stolen or burglarized from their owners, but rather were purchased legitimately at retail by what we call straw purchasers. That is, people who didn't have criminal records, people who didn't have significant mental health issues, who purchased these firearms and then sold them to the for criminal use to other people. Now, I said legitimately. That's begging the question, because it's not really legitimate, but it was legal technically. And the retailers could claim that they didn't know that these were store purchases, although there are indicia that strongly signal who store purchasers are.
So let me just understand that, Dan. So notice, these aren't just people who, on a one-off basis, are buying a firearm and then selling it to someone who commits a crime. You're saying that to be a straw purchaser is really to almost be kind of a black market business, that these are people...
Yeah, that's the business they're in.
Right, that's their business, is to buy guns and sell them to people who they probably know are using them for unlawful purposes.
Yes, and the point, the evidence that it is in fact possible for a responsible gun dealer to detect who is a straw purchaser and who is a truly legitimate purchaser is in another piece of very significant pieces of the data set that came out of this investigation, which was that a very small percentage of the retailers leak the majority of crime guns. Something like 1% or so of retailers leak more than half of the crime guns. Now, since, as we know, the police call the ATF tells them which distributor, the distributors know which retailer, they know who is leaking these crime guns, and yet they continue to supply these retailers, even though it's a small percentage of the retailers.
That's like opioid manufacturers knowing that there's a particular doctor or physician group that is just handing out Percocets and continue.
An excellent analogy. Yes,
yeah.
Very good analogy.
Yeah.
So they continue to do this. So what this discovery was had real legal significance, because there's the whole concept of duty in tort law is such that courts quite logically do not want to impose a duty on someone who cannot fulfill that duty if it's unrealistic. You say you have a duty to protect people. If you're not in a position to do it, then what's the point? And it's not favored in law. So if in fact the majority of crime guns had been stolen from legitimate purchasers, then what would be the point of putting a burden on a duty on gun manufacturers to protect people against this? There's nothing they could do about it. However, given this information, that the gun manufacturers, through their distributors, were actually supplying retailers from whom they could have withheld supply, then the argument for the duty became much stronger.
Well, and the other legal concept that's related to what you're talking about now is a concept in our civil law that's been around, I mean, for over 100 years, since really the advent of this concept of law that you can be civilly responsible for harm to another, which is the concept of foreseeability. So if the manufacturers know and can, be easy to say, well, I made the gun, but I didn't know someone was going to use it for an unlawful purpose. How can you hold me responsible for that? But if, as you're saying, the data shows that they can know in a significant number of cases, then they can't foresee it. They can't claim later that they had no way of knowing.
Exactly. And so what began to happen is that the courts were beginning to treat these cases somewhat differently. So that if, for example, in the Bullseye Shooter case, I don't know, some of our listeners might possibly remember, this is a series of shootings that occurred in the Washington, D.C. metropolitan area around 2001 or thereabouts. I don't know the exact year. Anyway, that was a case in which the firearm in question had been purchased in exactly these circumstances. And while the plaintiffs could not prove that the manufacturer or retailer had specifically known that the purchaser would shoot people with the gun, the negligence in this sale was such that the defendants, the manufacturer, retailer, and so forth, settled for, I think, a few $1 million because it looked like the law was going to evolve in that direction, and they might have been liable for considerably more had they gone to trial. So at that point, the NRA began supporting legislation to, as you prefaced our conversation by saying, to provide a substantial immunity to the gun manufacturing industry from suits for negligence or public nuisance. And Senator Larry Craig, then a Republican of Idaho, was the chief sponsor of this legislation. It came forward, I think, initially in 2003, but John McCain succeeded in putting in an amendment that would have included some kind of burden or responsibility on gun manufacturers. I don't remember what. And Senator, goodness gracious, California, Feinstein.
I've heard of her.
Yeah, right. She also was able to get an amendment that I think would have extended the Brady law. So the NRA, with those amendments, the NRA turned around and said, "No, forget it. Don't pass this thing." But a couple of years later, with more Republican senators in the Senate, they were able to get a straight version of Craig's Protection of Lawful Commerce and Arms Act through, and that essentially ended this trend in the law, because by federal law, which supersedes preempts state law on the subject, the kind of lawsuit that would have resulted in a victory for the plaintiffs in Bullseye Shooter was no longer feasible. Now, as our audience should understand, that this is a radical departure from hundreds of years of Anglo-American legal tradition. That is, to immunize an industry against its own negligence or nuisance is virtually unheard of. There is one small exception that is far more justifiable for manufacturers of vaccines that do in fact save millions and millions of lives, but that could be put out of business by a very small number of successful lawsuits. But that is the only other exception, and that one has some justification. This one is, I'm tempted to say, insane. It's an absurd piece of law. It's a radical departure from Anglo-American legal tradition, and it serves absolutely no useful purpose except to allow the gun industry to continue to supply those retailers who reach the bulk of guns to the crime market with impunity.
Well, let me just back up for a second to further understand the vaccine example, because as you point out, that's perhaps the closest next well-protected industry that we have in this way. But even there, we know vaccines, there's a certain percentage of people that are going to have a bad reaction to the vaccine or are going to suffer, in some cases, a very serious injury from taking a vaccine. But the law doesn't fully immunize the vaccine manufacturers. Instead, as I understand it, it creates a claims process, and there's a special court and there's a special claims handling process that people who have suffered an injury as a result of taking a vaccine can go through that claims process and receive at least some kind of compensation for their injury. So they're right. So, and that I think is supported by the government, maybe even by some government funding. I'm not sure about that part of it, but I think you have to explain what exactly the scope of this protection is, because I think that illustrates, as you say, just how radical it is to carve out an entire industry.
Let me say that both the gun industry and some of those brave souls who continue to try to litigate are very quick to point out that it's not entirely absolute. If there is proof that if the plaintiffs can prove that the manufacturer, retailer, and so forth have in fact violated the criminal law, then they can proceed with the lawsuit. But that is, especially under the conditions we were just talking about, that is almost always an insurmountable obstacle, because they sold these guns. There's nothing, the law doesn't say you can't sell the gun. It doesn't say, what is a straw purchaser? By definition, someone who does not have a criminal record or a mental health issue. So ordinarily there is no a way to show that the criminal law has been violated. And so, in effect, it's a pretty absolute immunization.
Well, you'd have to prove some type of intent in order to be successful in a criminal prosecution, and that would be
right.
That'd be a big part of why that's so hard.
Sure, it's virtually impossible.
But the other type of claim that isn't included in this law, the Protection of Lawful Commerce in Arms Act, which I believe was passed in late 2005, is again something that probably doesn't even begin to address the issue, and that is if a gun maker makes a defective product, and because of that defect, somebody suffers an injury, which one out of every who knows how many, in a particular line of gun products might be a defectively made gun.
Yeah, to be honest, I don't regard that as quite so inconsequential. For a number of years, there were certain manufacturers that continued to manufacture seriously defective guns, which caused a fair number of deaths and injuries. I mean, nothing like the mass shootings and so forth, but or even just the daily toll of normal shootings, but still a substantial enough number so that it was pretty outrageous that they continued to manufacture these things without making the fairly inexpensive corrections they could have made. So I do credit that aspect of it. It's useful. It's not entirely inconsequential, but compared with the the crime gun problem, it is.
Well, and ultimately, there's no way to make a gun really safe. I mean, you can protect with things like safety locks and things like that, but if somebody has an intent to use a gun for the purpose it was created for, which is to, fire a bullet or a large number of bullets in the case of a semi-automatic or automatic weapon, it's going to hurt somebody. That's the whole point of it. Just to add to the relevance of this conversation, in addition to the great number of mass shootings that get and appropriately get a lot of public attention, I noted this morning an article that came out which looks at the data that the Centers for Disease Control gathers and has gathered since 1979. And this data is just out, I believe as of today, as we're speaking, that in the 40 years of tracking gun-related deaths in our country, 2017 was the deadliest year on record, with almost 40,000 Americans killed by a gun. And this data shows that in our country, Americans are 25 times more likely to die because of a gun than any other advanced country in the world. So these are pretty remarkable statistics, but what it means is that each of those almost 40,000 people who die has suffered, and this doesn't even get to injuries, non-fatal injuries relating to guns, but just 40,000 deaths from guns. That's a lot of people who have suffered not only the loss of their life, but the losses to their spouses, to their children, to their families, which represents, as we started to say in this conversation, an economic loss that ultimately they bear, because compared to other causes of death where there might be some recourse in the law in our courts to compensation for those losses, there is no avenue for that now, thanks to this law.
Yeah, and I think what I want to emphasize that the repeal of the Craig law, the Protection of Lawful Commerce in Arms Act, this should not be offensive to Second Amendment adherents. The NRA, of course, hates it because the NRA, and when I say the NRA, I mean the leadership of the NRA, as many people know, the members of the NRA, when polled, often take different positions than the NRA itself. But the NRA, understandably, I suppose, represents the interests of its financiers, of its funders, and that is the gun industry. And the industry simply refuses to bear even what I believe is the sustainable economic burden of acquiring the kind of that insurance that you talked about earlier that would cover this kind of cost.
But of course they're enjoying this tremendous protection. Why should they? I mean, why should they object? They're the beneficiaries.
And by the way, the insurance costs would be minimal if they simply stopped supplying those retailers who were shown to be regular suppliers of the crime market. So, but of course, and what I'm about to say may sound unduly cynical, but I'm not sure it is. I would speculate that the reason that they don't want to stop supplying the crime market is because the more gun crime there is, the more they can persuade law-abiding citizens that they need to buy a gun to protect themselves from the criminals.
So, in other words, you're saying it's cynical to say, but maybe there's a basis for saying still that it's not that anybody wishes anybody to die at the hands of a gun, but the more crime there is, the more people fear crime, and when they fear crime, they want more guns in the interest of self-defense.
Right. I mean, it's a possibility. Otherwise, it's a little hard for me to understand why they are so protective of that small percentage of retailers who leak most of the crime guns.
Well, again, I mean, you can analogize to the drug makers who make these, very addicting, opioid medications. If you ask an executive at one of these companies, do you want to see somebody addicted and die of addiction? I mean, I'm sure most people, unless they're, truly a sociopath, would say, of course I don't want anyone to die. But yet, at the same time, they want to continue selling their products, and their products need, they make profits from those products, and their shareholders enjoy the benefits of those sales. So, I mean, that's business. But I mean, you brought up the Second Amendment, and we've talked about the issue of guns and the Second Amendment on this podcast a few times, and I think it's important always to point out. We had a Duke Law professor on a couple of months ago talking about the Heller decision, which by the Supreme Court, really for the first time after years and years of litigation, recognized that the Second Amendment stands for an individual right to bear arms. But importantly, the late Justice Scalia, who authored that opinion 10 years ago, made it very clear in the opinion that, as with all other individual liberties, including those explicitly enshrined in the Bill of Rights, there is no absolute right. And so there is a right to bear arms, but that doesn't mean that there can be a reasonable limitation on that right. So even the staunchest pro-Second Amendment, pro-gun owning individual can't say that because there's a Second Amendment, we can't have reasonable limitations on that.
Yeah,
right?
And by the way, I should really state that I'm not a fanatical anti-gun person. I was actually a pretty good shot as a kid. I had friends who were hunters. I'm not a rabid anti-gun person, but this present state of affairs is virtually. I mean, I've used the word insane. I mean, I think one can be justified in calling it that.
Yeah. Well, there are other industries that have some protection. I mean, immunity is one thing, but I'm thinking of, for instance, the pharmaceutical industry, where the courts have really strengthened the idea of preemption, which is a concept that, and I'm not an expert on this, but something along the lines that when a federal law comes along and says there shouldn't be liability for this, you can't then have a competing state law that the federal law would preempt any state law or any state law type of claims like negligence that might otherwise exist. And the pharmaceutical industry, through the courts, has achieved a pretty strong degree of protection through the idea of preemption. How is that? How do you see that as different than what the gun makers have here?
I'm thinking about it. There are a few different types of preemption. There's explicit preemption when the statute says, and this shall supersede all laws. There's implicit preemption. There's something called field preemption when the scope of the federal law seems, the logic of it suggests that any contradictory state or any different kind of state law would render the federal law illogical. And this actually, to tell you the truth, I don't remember whether PLCAA has an explicit preemption or not, but it's quite clear that the courts are that it does preempt state law. So I don't.
Well, and the proof is in the pudding, Dan. I mean, we haven't seen a lawsuit successfully prosecuted against a gun maker in forever. I mean, right? I mean, you can't point to one. Yet we do see drug companies in civil cases all the time being found liable.
Prior to PLCAA, you had numerous lawsuits brought in many cases by municipalities against the gun manufacturers, and all those, of course, have disappeared. And the Bloomberg's coalition won a judgment against a bunch of gun business owners around 2001, 2002, and it was reversed on appeal retroactively because of PLCAA. So, it's definitely had an impact. By the way, your show is Good Laws, Bad Laws. There is another terrible law, which in some ways is as unconscionable as what we were talking about. Remember I said that these lawsuits began to take off because of the information we got from ATF about the straw purchasers, about the provenance basically of these guns, and so because that information produced that result, a Congressman T-I-A-H-R-T. I don't think he's a member of Congress anymore. I'm not sure whether he is or not. But in any case, the T-ART budget amendment of 2002, effective beginning in 2003, and has been renewed every year since then, prohibits ATF from releasing that information now, so that the data that demonstrates the stupidity of the current law is no longer available to the American public. I mean, how can we tolerate an anti-knowledge, anti-information piece of legislation?
Well, and this was in the story that I referenced earlier about the data on gun deaths, that there are also protections which the NRA has lobbied for to prohibit the CDC from even studying the impacts of gun deaths in our country and what the true dimensions are. Right? I mean, that
CDC, right. CDC can't study it, and ATF can't release the data it has. It's just infuriating.
What do you think, Dan, is the course? I mean, this was passed 2005, almost 15 years ago. Is there? I mean, I don't know how tapped in you are to what's going on currently with this, but I mean, do you see any change that might come about? This has been a very interesting year politically on the gun issue generally. First of all, there have been more mass shootings. The Parkland high school shooting has seen some movement in terms of how this became more of an election issue in the midterm elections, more so than it's been in a long while. We have Democrats taking over the House in a few weeks.
And I saw recently that for the first time in a long time, there has been more state legislation enacted in the past year promoting gun control than reversing it. So there is some wind of change, I guess.
Well, and again, this is another example where if you could have a reasonable conversation about the problem without it just being seen as two polar extremes, shouting at each other. On the one hand, oh my God, this is another example of a move to try to come and take our guns away, which is no part of this at all whatsoever. There has to be a reasonable way to talk about this, and one one obvious step, it just has to be to allow for the information to be available. How can we understand what to do?
Well, the solution is clear. Every American has to listen to your podcast.
There you go. And has to tell their representatives to change the course so that this data is available. I mean, these straw purchasers are in effect conspirators.
Yeah, I was joking, but I'm half serious. I do think people are not aware of the situation. I think you are doing a public service, and
Well, thanks. That's why we wanted to have this conversation. So thank you very much. This has been really enlightening and disturbing, but in a way that may inspire people to try to find out more. I want to thank Dan. By the way, this is just one of the issues that you were involved in over your career, and I'm just looking at your bio, and I know that you've also written a couple of books on the broader issue of being a watchdog and a person who looks to try to investigate so that so that our prosecutors can then prosecute fraud and waste and corruption, in our government. So Dan, who is not only has this incredible background, but teaches oversight, investigation, as well as ethics and accountability at the City University of New York, the John Jay College of Criminal Justice, and you can check out his bio there for more information on some of the books and some of the articles Dan has written. And we will certainly, of course, as we always do, spread the word about this episode and share it with as many people as we can. So I want to thank you very much for joining me, Dan, and for being on Good Law, Bad Law. Appreciate it very much.
Well, thank you for the opportunity.